everyone knows how, you remember how Judge Merchan, he gagged Trump the same way Chutkan had and basically imposed a gag saying that he can't talk about anyone aside from the district attorney and the judge himself, can't talk about their families, can't talk about witnesses, can't talk about anything like that. And I looked up the Supreme Court precedent, and what I found was that if the gag is unconstitutional, there's actually a cause of action that a reporter, like the media has. New York Times, back, I don't know if you're old enough to remember that. Remember the Joel Steinberg case? You ever read about the Joel Steinberg case? It was a terrible case that happened back, I think, in the 80s. You were
definitely wouldn't have remembered it because I was born in 88. So
right. Okay. So shortly before you were born, I think, was this Joel Steinberg case, which was a terrible brutality case that happened, I think, here in Brooklyn. And the judge had put a gag on the case. The New York Times said that this is an unconstitutional gag. He was gagging the lawyers, I think, in that particular circumstance. And the New York Times says this is unconstitutional. You have to let us be able to interview us because now it's affecting your restriction on his freedom of speech is affecting our freedom of press. So that case was New York Times versus Rothwax. And the court recognized that the Times and the media have a valid basis when someone is being wrongfully suppressed from speaking, that it affects their rights of freedom of press. So based on that theory, I went to the First Department and I said that the gag order that was placed on Trump was unconstitutional, and accordingly, that was inhibiting my ability as a member of the media. I happened to be a member of the New York media, so that was affecting my rights of freedom of press. And the issue I had, a lot of people when they hear this, especially people from the left, they assume that, oh, he's some crazy Trumpist. He just wants, to help Trump. This had nothing to do with Trump. This is so little and so tangentially related to Trump. It was much more that I feel what happened was that there was politicization that was motivated because of the name Trump, to say we're going to start changing Supreme Court precedent and looking at it in a completely new way. And now, because he's so vile, so evil, so dangerous, whatever it is, that we need to shut him up. And we're going to throw out the Constitution in order to shut him up. And we're going to ignore Supreme Court precedent. Because if you
Can I ask real quick on that other case that you mentioned? You said over the Steinberg case, it was New York Times v.
Rothwax.
Did that, was that adjudicated in the federal Supreme Court? Or did
that was in state.
That was, okay, so the highest court in New York is the New York State Court of Appeals?
Correct.
Yeah, okay, gotcha.
Right.
Okay, gotcha.
So under New York law, that I have a right as a member of the media to go bring this action on his behalf. And what I felt was I was frustrated with Trump's own claims. You have to realize that for Trump, his perspective was, this is all a political show. They're just coming after me for politics. They want to try to paint me as a criminal. They want me to say all these different convictions. And you see that the left, ultimately, when he ended up being found guilty, they kept saying convict, convict, convict. And he was correctly identifying that. So he leaned in from the perspective of this is political persecution, and they're silencing me because they're trying to cut me out of the politics, and it's an unfair suppression. It's a violation of my freedom of speech because I'm a political candidate. And my point was, I don't give a damn if he's a political candidate. He's an American. And we don't have a right to do that to an American, to silence an American, because if you look at Supreme Court precedent, there's what's considered a heavy presumption of unconstitutionality of any gag order. And if we start chipping away at that, in that case, they're going to, anytime someone is accused of a crime, they're going to say, he's a threat, we have to silence him. If they brought up some ridiculous tax charge on you, whatever charge on you, or on me, my channel is considerably smaller than yours, or someone even smaller than me, they can say that because he's speaking, he's riling people up against the district attorney's office, and accordingly, he's a threat, and we have to strip away his silence, his freedom of speech, simply because of the fact that he was accused of a crime, and we're afraid that if he takes to social media, he's going to go out there, he's going to start saying certain things, that we're going to get all these harassing phone calls, and we're going to get, we're going to get terrible people calling in here. That's not the balancing test that the Supreme Court set up for when you're allowed to inhibit someone's free speech. And I don't want to get too heady with the lawyer talk, but the reliance that they said in Supreme Court cases where they allowed to have a gag in the past, you go back to the 70s and the 80s, there's Shepard v. Maxwell, there's Nebraska Press Association versus Stewart, and they set up a balancing test, and they said sometimes the media is so badly hurting someone else's right to a fair trial and basically trampling all over their ability to have constitutional right of a fair trial. Sometimes in those circumstances, you need to dial back freedom of speech. And then you have to make sure that it's as limited as possible. And invariably they would say, this is not a good enough case. This is not a good enough case. And so basically you have to verify that for certain it's It's this exhibition of First Amendment rights that's stealing and trampling the constitutional rights. And then you have to say that the remedy is as limited as possible. There's no other possible remedy which would help protect this person's constitutional right to a fair trial. That's the balancing test they talked about. Are you understanding me? Because I know I get very lawyerly, and I don't want to. I don't mean to be. You're a very smart guy. I know that, but I want to make sure I'm being clear here so far. So they talk about balancing test, and every time they talk about this balancing test of constitutional rights, where it's your First Amendment rights are trampling this guy's Sixth Amendment rights or 14th Amendment rights, his right to a fair trial. So you have this competing balance there, and they said, well, okay, if you're really crushing him, you want to hear a crazy case?
Yeah, for a quick tangent, go for it. I got a lot of questions about this one, but if you want to do another one.
Yeah, it's on this. It's on this.
Yeah.
The Shepard v. Maxwell case, okay, it was back in the 60s before I was born.
Mm-hmm.
This guy was accused of murder, okay? And I think murdering his own family. Everyone in the media thought he did it. Everyone, all the papers going out there saying they do it. Picture in the 60s, a courthouse, everyone's smoking in the lobbies, wearing their hats, and the media with the press badge and the flash cameras. And they come to this trial, and the media is everywhere. I mean, everywhere, in the jury well. During deliberations, they're hanging out with the jurors, and they're like, you're going to find him guilty, obviously. I mean, this guy totally did it. So he ends up being convicted, and he says, I never had a fair trial here because the media was, just destroying me. And what the Supreme Court said in Shepard v. Maxwell is sometimes when the media and their expression of their First Amendment right of free press is being manifested so egregiously, so aggressively that it's destroying this guy's chance of having a fair trial, the court has to intercede and stop them from doing that. Otherwise, there's no fair trial. So that's when we'll say we're going to open the door. In general, if you're going to gag someone, we consider that a violation. We consider that something that has a heavy presumption of being unconstitutional. But look, you have to have a balancing test here between these constitutional rights. So, and then there was another case, Nebraska Press Association versus Stewart. There was a handful of cases the Supreme Court handled, which every time they talked about this balance between this balancing test. What the court did in D.C. with the Chutkan case, the same thing they did here with Merchan, is they looked at a completely different balancing test. They say the state has a right to a fair trial. Or sometimes they phrase it as the court has a right, which those are two different entities that they seem to glom together a little bit. And because the court is not getting a fair trial, that is now we get to see about suppressing his free speech. The Supreme Court has never allowed that. They've never endorsed that. They've never taken that position. That's in complete conflict with what the Sixth Circuit says. The Ninth Circuit doesn't agree that the court has a right to a fair trial. They don't agree with that at all. And they say, look, the defendant, what are we worrying about? We're worrying about defendant. It's free speech versus defendant's rights. Here, all the rights were on the same side. You had Trump's right to free speech and his right to a fair trial. They're both on one side of it. And then you have this court interest in fair administration of justice and having fair trials. The Supreme Court never endorsed actually creating a balancing test there. And I don't think we ever should, because I think that our freedom of speech is the most precious thing that we have. And I don't want to see that eroded. I don't want to see that you get arrested and that anyone gets arrested. I don't care if they're left, the right, Donald Trump. It can be, Mussolini. I don't care who it is. I don't want them being suppressed out of some fear that now the state is not going to have a fair trial. The Sixth Circuit, the way they worded it was this. They said, your right to a fair trial is a constitutional right that serves only the people. And the government must be the people's servant, not their master. And if they can't handle a tilt in the balance because a particular defendant has too much power, they basically can eat it. It's hard luck on them. The burden is on the state. And I don't want to see this change. We see in Texas, there's a whistleblower who they're looking to gag that's in the middle of going through the whole process of being gagged. This guy has 20,000 followers, and he only has 20,000 followers because he became a whistleblower. He's relatively in the social media landscape. He's a nobody, and the state has said, "Oh, he's too much of a threat. Sure. We have to silence him." Do you think that that's a healthy perspective for our court to take? That hey, if someone's going to tweet out things that the government doesn't like, that means that we need to silence them.
Absolutely, yes.
Absolutely,
yeah.
Why would you say that?
So I think the first thing we have to consider is there are definitely times where even our fundamental rights could be taken from us. We can say, whether we're talking about the state coming after them, right? When you try to figure out what form of review you should engage in, right? Rational basis, intermediate scrutiny, strict scrutiny. There are times where even under strict scrutiny, a fundamental right could be implicated that the state will survive a Supreme Court analysis from, where they can deprive us of a given right. There are times when even political speech can be implicated. The Supreme Court has developed balancing tests for that, like in Brandenburg v. Ohio, to figure out if you're directly inciting somebody to violence, where speech can be violent.
Right.
And then we have criminal statutes related to conspiracy to commit crimes, which those conspiracies could involve no crime in and of itself, but rather the fact that you've made a plan to do a crime and then you've taken one step towards it, even if those two things on their own aren't illegal, both of them together with the speech element included can be a crime, right? And I think these are pretty easy things where we all agree that like these are things that are probably good to limit our speech in some way on these things, right? But I do agree that it should be like very narrowly and specifically tailored, right? If somebody says, I hate my teacher, I just want to blow this place up, that's not enough, right? You need two people, you need a step taken towards an we need more, that's important. I agree. I think that one thing that I guess conceptually I would want to kind of push on a little bit is you say the state and then you say the defendant. I would argue to some extent that the state is also kind of a little bit the embodiment of the people as well, right? That when you're talking about especially criminal law, the public has an interest in seeing crime prosecuted, right? That's why they're criminal laws. That's why we have police officers. We've all decided there are certain things in society we shouldn't do in a criminal aspect, right?
I'm letting you finish your point before I respond to that.
So I think that I do agree that also as a society, we've decided that there is a burden on the state to prove crimes to a very, very, very high standard, that they have a very stringent set of rules that they're required to follow in how they gather that evidence and how they present it to the court. In every step is very important here. But I think that narrowly tailored gag orders around defendants that might be using extrajudicial processes to try to influence the outcome of that case. So, for instance, I think when it came to Trump, it was attacking the family member of the judge.
Judge Merchan's daughter, Laura Merchan.
Yeah. Or implicating like members of the jury. I don't know if Trump was doing that, but implications of like members of the jury, whatever. These are things where I don't see these serving a really good, if any, free speech purpose at all. But I do see how they could heavily intervene in that process of the adjudication of the trial itself. And much the same that somebody might say, well, gagging this person is hurting our freedom of speech because now it's been politicized. I think on the opposite end, you could say, well, this person is so popular and they have so much power with their speech that now they can politically survive any case because they can just make the appropriate threats or the appropriate statements to have a favorable outcome every time. And I think that is equally as concerning, I think, to an ordinary citizen.
I think that's a dangerously foolish perspective to look at the state as another entity, just like a person.
To look what?
You're looking at the state. You premised all of this as looking at the state as a litigant or a party here, and you didn't look at the unique position of the state. And you said because they're elected officials and they're representative body of the people. In that case, we can view them as if they are the people. Which by that logic, you don't need to have a Bill of Rights. By that logic, you don't have to worry about anything as far as the state running amok, as far as the state being in danger, which is something that historically, when you look back to our founding fathers and to the thousands of years of historical precedent before that, you can say the state is notorious for trampling people. And you're saying, well, the state is now the representative body of the people, therefore they're not a threat. They have a unique position because they are the only ones who are authorized and licensed to carry guns, to press charges, throw people in jail. They have a unique position that is not remotely akin to you or me or any other assembly of people that are put together.
Sure, but we've given them that power because we feel like there are some things in society that are so bad, that are so egregious that we want a third party.
100%.
Yeah,
I 100% agree with that. Mm-hmm. But that's why we have certain checks as to what powers and abilities they have, and say we are going to look at them as a completely different entity. So when you're trying to frame them as if, well, they're just the will of the people being asserted, that's not a fair way of looking at them.
I'm not just trying to frame them that way, but that is what they are to some extent. Yeah.
I mean, the
laws are things that our representatives pass.
Yes.
And then the police are enforcing these laws, hopefully in ways. DA is often elected or appointed position by the mayor. Your attorney general for the state is an elected position, I think, generally, or might be appointed sometimes by the governor. But these are people that they're
representative of the people.
Yeah.
I'm not disputing the fact that they're representative of the people.
So the people have vested their power in the courts and the executive.
That doesn't mean that they don't. Once they take that position, that they don't move into a completely different sphere than you or me. I mean, I think you recognize that.
Yeah, of course. They're entrusted with an awesome ability, and they should have restrictions on on those
and
votes.
they have to have certain checks on them. And part of those checks is that, and part of the things as far as making it tougher for them that the Supreme Court has always recognized is that you can't to look at them as if they're the same as the people. I mean, I understand that they pass a law because they're elected officials, but to say that they're the same as the people.
I've never said they're the same as the people.
Okay, so I'm not sure why you would bring that element into the entire equation.
Because I think that your framing is just viewing the state as a wholly antagonistic party that just comes down to harass ordinary citizens with their petty laws.
I think that's the concern. That's why we have a constitution.
That might be the concern. My concern right now as a citizen, and I think my concern is far more valid because now there's a convicted felon who's going to be the president. My concern is that I want criminal law enforced in the United States. I think all of us share that concern on criminal law. It's why the state can literally take your rights away from you, and we all agree that that's a good thing and an okay thing.
Yeah, I definitely, obviously, I agree with I agree with having a justice system. The idea is that the justice system has to be something that they're held to the toughest standard possible because we are giving them the unique capacity to imprison people.
I don't think
is that a necessary evil? Is that a necessary? I wouldn't even call it evil. Is that a necessary element toward maintaining justice in our society? 100%. Obviously, I'm simply saying that I think that you're getting so bogged down because you fall in line with the perspective that he is some sort of unique evil.
I'm not even talking about Donald Trump right now, and I'm not falling in line with anything. I don't think that the goal is to make it the toughest possible. I think the goal is to make it the fairest possible.
Then why do we have beyond a reasonable doubt? Why is it such a high standard, do you think?
To make it as fair as possible, to make sure that people aren't being... Because when we talk about a conviction in criminal court, we're depriving people of rights that are guaranteed to you under the Constitution. Negative freedoms, these are very, very big things, right? So beyond a reasonable doubt is a standard that is so high, is a burden that's so high. But I mean, it could be...
Including your freedom of speech.
Sure, but it could be...
But we're taking away your freedom of speech before you even convicted. You're just charged, and we're going to take away your freedom of speech.
It could be beyond a reasonable doubt. It could be 0.01%. It could be 0.001%. We could say that we could say that the judge has to walk to court with ankle weights on, or that you can make it more burdensome if you want it. But the goal isn't just make it burdensome for the sake of being burdensome. There's an idea of fairness.
It's to be reasonably burdensome.
Sure, yeah.
But over here, so now you're saying as soon as a person is charged, that it's a good idea for us to silence him. And I want to just get into your brain as to why that would be a good thing.
Well, do you think it would be, let's say, hypothetically, you have a person who gets charged with a crime. They do their first day in court. Afterwards, they come outside and they talk to the press, and they say, I saw the jurors here, and I would just say if I was on the jury here and I voted to convict me, I would expect, some of my followers to show up and, teach these people a lesson or whatever. Do you think that would be like an okay statement to make?
I mean, I would need a lot more context over here. But I'm over there, and to the extent you're saying he's making a threat, okay, so there if someone's making a direct threat, so you're right, there are laws that prohibit that.
Vague enough that it wouldn't survive a Brandenburg test. It's not like an incitement to riot or...
And I agree with you, that probably would not survive a Brandenburg test.
Yeah, so then...
but you're saying the idea is that he's trying to level some sort of veiled threat at the jury that if you convict me, folks are going to come after you.
Yeah.
I mean, I don't like that kind of speech at all.
I'm not asking if you like it or not. I'm saying, do you think that this contributes to a good environment for justice?
Do I think that contributes to a good environment for justice? I think that finding ways to prescribe that is so difficult in a way that actually is fair and humane to society itself. I don't think gagging somebody so that they can't talk about members of the court or members of the jury. You said he shouldn't be able to talk about members of the judge's family, even if the judge's family is potentially politically motivated to come after him. But the judge's members of the family are not the judge. No, okay, fine. But if you feel like he should recuse himself, there's a process in court to ask for a recusal. That's which he basically decides. Do I want to recuse myself or not? And there's a lot of attorneys, even on the left, couldn't believe that he didn't recuse himself. I don't agree that a lot of people on the left can't believe that he couldn't recuse himself. Because if you're within 6 degrees, if you're considered within 6 degrees of potential taint, a judge is supposed to remove himself. He was within 1 degree. His daughter. I don't know where that came from, but I would bet my whole life that is not real. I'm within 6 degrees of Hitler. You're probably within 6 degrees of Hitler. There's no shot that there's any rule. It's not 6 degrees. It's not 6 degrees the way you play 6 degrees with Kevin Bacon. There's different classifications as to like someone being a cousin versus someone being a sibling versus. That's when they talk about degrees. It doesn't mean like he was in this movie with that guy, was in the movie with that guy, was in the movie with that guy. It means that there's quantifications as far as how many degrees of closeness someone has to someone else. And that was the 6 degrees that I was referencing there. But his daughter is the closest possible degree, and she's literally she's literally what with the head of the campaign of the PR machine for the DNC. You want to tell me that for him to come out there and speculate and say, hey, perhaps Judge Merchan is not the best person to be handling this case when his daughter daughter is the one who's the chair of the DNC, do you think that that helped justice? Do you think that actually helped the left? You don't think that that hurt the left, that people saw that this judge is gagging Trump, that this judge has a daughter who's making millions of dollars, and her company is making countless millions of dollars every year for the DNC, and that's the person whose father is presiding over a criminal justice case for him and ultimately convicting him? You think that helped the left rather than hurting them?
So first of all, it doesn't matter who it would have been. The response would have been exactly the same from the right. The second point would be if you go through the process and you're not happy with the process of what came out in court and you do your appeal or whatever, then is it left up to the defendant to decide whether or not they need to publicly excoriate their judge because they feel like their judge was too tainted? What if Smith would have said, Jack Smith, what if he would have said, I don't think that the Judge Eileen Cannon should be allowed to preside over Trump's case because he appointed her?
Okay, he could say that.
And then if she doesn't recuse, does he go to the media and start attacking her and attacking her family?
He can say that, but that's never been considered a basis for recusal. When you have financial interest or someone within one degree of you has financial interest, in that case, that is a basis for recusal. That's different from saying this person was appointed.
So there's another case where a person had a daughter who was in a political camp that was different than the defendant, and that judge has recused themselves. There's a direct legal precedent or a direct precedent for a judge recusing themselves.
You're asking me whether he legally had to recuse himself. I'm telling you right now, he did not legally have to recuse himself. I'm simply saying, I'm very happy that this thing went the way it did. Because I'm going to tell you right now, you elected Trump.
Well, I didn't, but...
No, you, Destiny, you and all the other leftist political opponents, you and MSNBC and all of you who pushed and pushed to persecute Trump, there is no way he would be sitting in the White House come January 20th, if not for the likes of you and me. I feel like it's a joint effort. We've been working towards getting him elected.
Donald Trump could have raped a child on camera and people like you would still vote for him.
Yes,
so there's
yeah,
absolutely...
yeah, you want to know why?